It's now 6:30. We'll go ahead and get the meeting in order. I want to thank everyone for coming out tonight, and if I could have Colton Simpson, our Deputy Judge Exec, if everyone could stand for our prayer.
Let's pray. Heavenly Father, we are so thankful for this day and all the blessings that come with it and the many opportunities that you give us each day to do better for ourselves, our families, and our community. Lord, I just ask you that you be with the court this evening. Let everything they do be for the betterment of our community and most importantly for your will. And it's in Jesus' name we pray. Amen.
Amen. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You may be seated. Thank you. If I could have the clerk call roll.
Magistrate Humphrey.
Present.
Magistrate Coldiron.
Present.
Magistrate Riley.
Present.
And Judge Executive Chuck Dills.
Present. Item number 5 on the agenda, approval of the regular meeting minutes of August 17, 2021.
Having previously read the regular minutes for August 17th, 2021, I'll make a motion to approve as written.
I second.
I have a motion made by Magistrate Humphrey, a second by Magistrate Coldiron. All in favor by saying aye.
Aye.
Any opposed? If not, motion carries. Item number 6 is fiscal matters. First one's approve the claims on the general fund, the road fund, the jail fund, along with all transfers presented dated August 18th, 2021 and September 7th, 2021.
I make a motion this evening to approve the claims against the general fund, road fund, and jail fund, along with the requested transfers as presented, dated both August 18th, 2021 and September 7th of 2021.
Judge, before seconding that, I'd like to bring out two important revenue source. Well, one revenue source. The transient tax that we have been charge for people coming to stay in the county, that gets presented back to the Grant County Tourism every quarter. And as of this quarter, we actually had our highest revenue come in at $124,147. So you can see with what's happening in the county how much the tourism is gaining by that. And it's with those funds that we're able to fund the parks and provide some special projects for the county. So I think that's really important to note. You know, it is a good thing. And also in our road fund, we was finally able to buy a roller for $60,000 that was badly and sorely needed by the road department. So with those claims, I second the motion to approve them all.
Okay. I have a motion made by Magistrate Riley, a second by Magistrate Coldiron. All in favor by saying aye.
Aye.
Any opposed? Motion carries. Moving down to item B, we have a resolution 0006-21 on James Brown zone change from Agriculture 1 A1 to rural residential on 3 acres on the south side of Napoleon Zion Station Road and 1.5 miles east of Little Sugar Road, Dry Ridge, Kentucky. Is there anyone present for or against that zone for James Brown? If not, Saints, the Planning and Zoning has passed that on to the Grant County Fiscal Court for our consideration to pass that zone change.
Upon the recommendation from our Grant County Planning and Zoning, I make a motion to approve James Brown's requested zone change from A1 to rural residential RR on 3 acres on the south side of Napoleon Zion Station Road and 0.5 miles east of Little Sugar Road in Dry Ridge, Kentucky.
I second.
I have a motion made by Magistrate Riley, a second by Magistrate Coldiron. All in favor by saying aye.
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 Any opposed? Motion carries. that resolution be passed on back to planning and zoning for their signature. Moving down to item C, we have a resolution of 00-05-21. It's United Skills Service, a zone change from Agriculture 1, A1 to rural residential on 18.857 acres on the southwest side of Baton Rouge Road, Dry Ridge, Kentucky. And it appears, I know that Brandon Vogler, are you here representing some of the parties on this matter?
I am, Judge. I'm here, I think my law partner, Mr. Gatlin, is representing the P&Z hearing. He's unavailable tonight, so I'm here.
Okay, if I could have the county attorney on how we'll address the hearing, or not the hearing, the actual argument.
Yeah. So the Zoning Commission has conducted a due process trial hearing, and they have made factual findings and recommendations to this body. And at this point, it's my understanding that the fiscal court will conduct this in a argument type of hearing without taking additional testimony and or findings of fact. And if Mr. Volker wants to speak to those, that argument type of hearing, he may do so. I'm assuming at this point the floor would want to recognize him.
That's correct. The fiscal court has reviewed the tapes from the hearing that was put on by planning and zoning, and all the testimony that was put on there. So if I could have you introduce any argument to it.
Sure. Thank you, Judge. Mr. Bates. And I agree as well with Mr. Bates that it would be inappropriate to have more evidence presented here. And I know Jason Wilson, Steve Noah, and Mike are here, and I know we've discussed it, that really what is before you all tonight is just the record at hand. And that's all I'm going to address. You know, at this point, that public hearing was conducted. I've got the findings that were sent to me, and that's really all I want to address. I think as a preliminary matter, you got to look at KRS 100-211, as well as the findings of fact. And the only thing I would, and I brought two cases that when I'm done, I'll turn over to the county attorney. But as I walk through this, I want to quote to, there's a case, Caller v. Eisen, and it says, and it was quoting from another, Louisville v. McDonald, Kentucky. We held that requirements of the proceeding conducted in order to meet constitutional due process must include a hearing, the taking away of offered evidence, a finding of fact based on a consideration of the evidence, and conclusions supported by substantial evidence. As the findings were nothing more than a restatement of the legal requirements, they were not specific enough to permit a meaningful review by the court. Well, the way you all are sitting right now is similar to a court. You all have a record at hand, and I'm not going to talk about anything, what he said, she said, anything else. I'm just going to stick to the record. So what I know to be the record, as the judge pointed out, is the, first of all, you got the application. So there was an application that I'm sure you all have. And the significance of this application is if you look at KRS 100.213, it sets forth what's required for a zone change. So for those of you not familiar with it off the top of your head, I've got the statute with me. And it says, basically, before you can grant a map amendment, it has to be one of two things that have to happen. It has to be in agreement with the adopted comprehensive plan, or in the absence of such, one of these two. The existing zoning classification given to the property is inappropriate, and the proposed zoning classification is appropriate, or B, and this is the one your P&Z adopted, there have been major changes of economic, physical, or social nature within the area involved which were not anticipated in the adopted comprehensive plan, which have substantially altered the basic character of such area. So that's the statute. I look at your application. It actually mirrors that. Number one, the applicant was asked, how will the proposed amendment conform to the comprehensive plan? So basically your application is saying, do you meet box one? Is it consistent with the comprehensive plan? Has the comprehensive plan said this area needs to be zoned RR, should no longer be agriculture? He says, would still maintain large lots, just smaller than 5 acres. That's not a statement under a comprehensive plan. Your comprehensive plan has goals and objectives, land use elements, things that are required by KRS. That question, that doesn't answer it. Next one. Is the existing zoning classification of the property in question inappropriate or improper? Simple question, yes or no, state your case, why it would apply. Wanting to build 6 to, I think, 10, 8, I don't know, residential houses would take 30 acres under current zone. I guess he's saying it's improper. I don't know. But number 3, which is the one that P&Z appears on their minutes, went with, major economic, physical, or social changes. He specifically says no major impact. So the application on its face doesn't meet the statutory required language. Again, this is the law. So then I go and I look, okay, application, but you still had a public hearing. So where do I go from there? I go to the hearing. That's this hearing is your record before you. And if you look at KRS 100.211, it actually spells out what you all have to have and says, and let me find it for you, under 211, 2B, make findings of fact and recommendations of approval or disapproval of the proposed map amendment to the various legislative bodies or fiscal courts involved. So you've got to have findings of fact and recommendations of approval. It also says down here, the findings of fact shall in the legal world is like a stop sign. You can't roll through it. It means stop. You have to stop. You have to do something. Shall include a summary of the evidence and testimony presented by the proponents and opponents of the proposed amendment. So, okay, that's where we get to this hearing. So here's your hearing. This is that summary as required by KRS. The applicant, Mr. Taylor, 2 things that he cites to are, he said Baton Rouge Road. These are things that when I looked through it, how to address this impact change. Let me show. Member Darren Spare made a motion to recommend approval of the request because there have been major changes to the area not anticipated by the plan, with the condition that there be no manufactured homes on the lots, no lagoons, and the property to develop according to a new plan submitted showing 6 lots. Okay, so he makes that motion. They adopted, I believe it was 6-5. But again, you have to have evidence. We all might want something to happen in life. I don't personally like to wear a mask, but people seem to put records out there. Whether they have the authority to do so or not is sometimes debatable in this state. But more importantly, I'm just going to take the applicant at his word, just like I did with the application. Baton Rouge Road is a narrow road, but you just have to be careful when driving on it. And I want you to remember something, because I'm going to show you your comprehensive plan, which is what governs everything we do in zoning in Kentucky. So he said he acknowledged it's a narrow road. You have to be careful when driving it. Apparently there's a discussion about Airbnbs. People coming to Airbnbs would drive together and have less vehicles than a single-family home. He said these people would not know the road and therefore would go slower. I've represented government a long time. I've not seen people drive slower that are out vacationing or something coming to an area. Generally, they're lost. They don't know where they're going. But the significance of that is there's nothing in the record that supports major change. And what's further illustrative of that, if I look at it, you all have a comprehensive plan that was adopted in 2016 by law. Every 5 years, you have to do a review of your comprehensive plan if you have planning. It's the only way you're allowed to have planning in the state of Kentucky. You look at things called land use elements. You look at, there's goals and objectives. The only thing that you all actually approve are the goals and objectives. There's no reference to goals and objectives. P&Z hung their hat on this major change. There's no record of major change. In fact, your comprehensive plan, if you look at figure 7.4, a list of needed improvements to accommodate future development. Plain numbers show needed road connections, while block numbers show needed road improvements such as alignment, widening, or intersection improvement. In your comprehensive plan, you've actually addressed Baton Rouge Road. And you've said no development until such a time Baton Rouge Road widens and is realigned. So ironically, his exact evidence presented, it's a narrow road, people may be lost, but we hope they drive real slow. You all have already spelled it out. When Planning and Zoning adopted their comprehensive plan, they flat out said, Baton Rouge Road, a list of roads, needs certain things done before it's appropriate to open up the floodgates and allow basically single-family homes on less than 5 acres. So again, this is just taking your record at hand. What's the significance of that? Well, if you don't meet those, you just can't say, there's a material change. There has to be something in the record. And if you read the recommendation, I'm going to go through it again, Mr. Sparr's recommendation, and this is something just going forward, looking at your minutes on some of these things, I'm not sure there's proper hearings, proper findings are being made in general, but if you look at the finding and what he said, and again, you watch videos, you read the minutes, he says, there's been major changes to the area not anticipated by the plan. With the conditions, there be no manufactured homes. Major changes to the area. There's nothing in the record to show a major change to that area. In fact, your existing comprehensive plan, which is what governs you all, said nothing should go there till Baton Rouge Road is widened and realigned. Then you get to 2 Kentucky Court of Appeals cases. I'm going to give these to Mr. Bates, the one I mentioned earlier. You just can't merely state a major change. We find a major change, but there's nothing there to support it. If you guys remember that old Wendy's commercial, I think it was that little lady saying, "Where's the beef?" You still got to have some beef. You just can't make something up. The Kentucky courts have said, basically, you cannot, and this is a quote from the Beechwood case, a mere parroting of the words of the statute was not a sufficient finding of fact in a zoning matter to justify a map amendment zoning change. So what the courts are telling you, you can't play politics. You got to have an evidence. You got to have a record. And you don't have that in this case. You basically have maybe, I have no doubt, the 6 people who voted in favor of it, they probably are okay with it. They probably agree with it. But it's not whether we're not voting for prom king and queen here. We have to look at the evidence. We have to look at the zoning. And there's just nothing there in this record. Because again, by law, you've got to make a summary. Those are generally called the minutes. That's it. I can't help the fact that the record wasn't developed. But when you read it, there's 2 cases directly on point that basically spell it out. This finding is a mere, they basically said, the finding does not contain a statement of what major changes have occurred. Somebody could show me in this document where those statement and changes are. I'd love to know, but guess what? This is from your planning and zoning. They don't exist. So when they don't exist, regardless of whether you like the applicant or you dislike the proponents, opponents, or anybody else, you take all the emotion out of it and you just apply the law. You apply your zoning and you apply the playbook that the legislature in our state enacted when they granted zoning. There's a lot of things zoning-wise that people may or may not agree with, but it's a quasi-judicial type setting. You're dealing with property rights. Not only property rights of the folks on Baton Rouge Road, but the property rights of the applicant here. And if the applicant believes there was a major change, they were certainly free to argue it. They just didn't do so. And more importantly, generally, and most 95 times out of 100, I'm usually on your side of the aisle here advising government. And what I'm saying is, where's the findings? First thing I look at is that comprehensive plan. If it's not in that comprehensive plan, is it not designated in a land use element? The answer is probably going to be a hard no from a legal setting. Then when you're going to go and use that kind of major changes or something, you better have a heck of a record at hand. And I would argue there's no record at hand here, and I think you're opening yourselves up to significant legal recourse if you approve something without a record at hand. And at this point, I'm going to conclude. I'll answer any questions you all had of me, and I'm going to give these to Mr. Bates in 2 cases. And I think, if I could just get everybody from Baton Rouge Road who supports, is against this. Again, we're not taking testimony, but just so people know who all's here and what's up. And I don't think, unless, obviously, I agree with Mr. Bates. This is not a time for further evidence. I guarantee everybody would like to stand up and talk, but it would be inappropriate to take on further proof. At this point, it needs to be just decided as a matter of law and the record at hand, and I agree with Mr. Bates on that. So I'll conclude my remarks at this point.
If you don't mind, give us a second to look over what Brandon Volker's presented to us.
I can give you those.
You can take a vote on the matter at this point, based upon the record that's been presented to you, and taking into consideration the arguments that we just heard from Mr. Volker. Obviously, we have not heard from the applicant yet, but you can also then table the issue if you want to go back and review those records again, and consider Mr. Volker's arguments, and table it for the next meeting for a vote at that point. Or you can, obviously, I guess there's actually just two options now, I think, all the way through. So that's your options at this point. Vote and/or table and review the arguments and the findings at this point. I mean, it's an argument type of hearing, so, I mean, you've heard from the opposition. I don't know that the applicant wants to speak or not. It's not my position to advocate for him one way or the other. I'm just, if he's here, he can talk. If he doesn't wish to, that's up to him. The record is what you guys are considering, which is what Mr. Volker just referenced. That is the record that was made to the Planning Commission.
Let me refer to you, Stephen, as our legal counsel. If I understand right, I mean, planning and zoning has passed this, and it's come to us. If this is not passed, with him having over 1,000 foot of road frontage, he would be able to go in and put houses in by flag lotting them? Is that
Yes.
correct?
Yeah, he
With
could
the-
flag lot them at 100
foot of road frontage.
100
And-
foot of road frontage.
And then there's such a thing called, I won't have the terminology exact,
Board
but.
of Adjustments.
Right, the Board of Adjustments can also take applicants from constituents that could even be reduced to 50 foot. And to my knowledge, I'm not aware of many of them being denied for constituents who seek the option of 50 foot based off of their land. And so the over 1,000 foot of road frontage would mean that there's at least 10 properties if what I would call a conditional use, but it's a different word. It could be as many as 20 because it could be reduced to 50 foot of road frontage for
Obviously.
development.
That would also be conditioned upon the
If they approve that.
availability of how to maneuver those particular entrances onto the road and whether there's adequate ground to do so. I mean,
Exactly.
Those aren't issues that are, the plan does acknowledge those 100 foot, or 100 feet of road frontage as a viable lot.
Which is what.
So
we
under
also-
the current zoning, though, he could go in there with 10 driveways, 10 different lots,
And develop it
and
without.
develop it
without
without
approval.
anybody saying a word, as long as he stays with the proper
If he
zoning.
gets, he obviously has to have each lot contain, I believe, the minimum is 5 acres.
5 acres. But then
Correct.
he could have lagoons on that, whatever's necessary, as
all
long as
those
it falls into
You
the
can do all
proper
those things.
language.
Yeah.
So you have that, or you have one street with 6 houses, no lagoons, with the restrictions already here that says he can't build anything else unless he comes back before P and Z. Okay, that's
And the
facts.
court.
And I want to add this, you know, maybe I'm out of turn here, but whoever put this letter out, y'all know who it is. I'm not even going to ask. All of you got a copy of it, but this is false information. This is not based on facts. And what we're going to base it on is facts. To all the neighbors,
Yeah.
you know,
Brady, did you have a question? Or did you have a comment?
I mean, I've dealt with that issue before, when you find something, my only spot would be your zone change, while you've got one plat of 18 acres. I believe I don't think they're planning on building, I think the zone, the portion is only part of it. Once you zone 18 acres, the zone change would apply to it all. And then you're gonna have whatever, you have up to 18 lots. I'm not sure you can restrict that. I've actually
You know,
litigated that matter in federal court.
Well, the commission put that he can only build 6 lots
right, that's in the
without coming back
resolution.
to the planning and zoning on the resolution.
Yeah, usually you can. I don't know who their counsel is. I think that,
But normally that would be a zone violation if he built a 7th house.
yeah, but if the zoning applies and the density's there, I don't know how you can take it away. Not being argued with spot zoning.
Plain and simple. If he doesn't stick with the rules, and it's a rat hole out there, it ain't gonna get approved.
Yeah, I mean, it's, again, I
Wait,
don't, I'm not.
either way.
I'm not here to address the stage one
want-
development plan or something like that. I'm
You
just-
want 10 driveways or you want 1?
So, I'm sorry, Mr. Volker, I'm not for certain are you suggesting that once that plan is approved, that it's not limited to what they've recommended? Is that your
You're
suggestion?
familiar with US 27 in Alexandria. Years ago, I represented the couple selling Speedway. They changed the zoning, then they wanted to control what went in there. Federal court said, nope, doesn't work that way. You make a zone, you make a zone, for better or worse. We actually went up, ironically, the reason it resolved itself was Sixth Circuit Court of Appeals ruled that we had the right to sue the elected body individually. And ironically, that usually has a chilling effect on getting things done at that point, and we got it done. But that was the issue. Judge Bertelsmann said there's a difference between zoning, which is kind of this legislative body, versus application of your zoning code. So, again, I don't know. I mean,
Now, was that zoning residential or
it was
industrial?
commercial, but the principles seem the same. I mean, it's,
Well, I mean, under industrial zone, you can put in, there's several entities that will fit in that zone.
Yeah.
Under the rural residential zone, the only thing can go in there is the single-family homes, and if it's a stipulation from the commission before us to pass the resolution, it stops at 6 houses. So anything above that would be a zone violation.
yeah, I mean, well, I don't know. Again, that's something you would have to decide down the road if they're held to that or not. I mean, on your road and your curb, I don't know what your curb cut rules are for encroachment permits. Generally, you don't allow a single owner to subdivide stuff to kind of usurp the purpose of zoning. But again, I don't know how you all are applying your encroachment permit process.
Yeah, the plat I understand
I'm not
is
into that.
a street built at county specs with 3 houses down the left, 3 houses down the right, off the plat.
Yeah, I don't, like I said, I'm here to talk about the zoning, the record at hand, and it's just, my position reading it is, there's just not enough findings. Now, whether doom and gloom could come something else, that's really a separate application, a separate analysis. Encroachment permits need to stand on their own. I'd be probably what they call an ID plat, I would assume. Generally, an individual house lot's going to be governed by an ID plat. Whatever rules apply to that, really, it's not germane to a zone change. The issue in front of you, my thought is the issue in front of you all tonight is, does this meet KRS 100.213 or not? Certainly, people can argue there's no way to skin a cat and try and do something. I don't have that in front of me. I'd be hard pressed to think that you can go drop 10 single flag lots. I know you couldn't pull it off in Boone County or Campbell counties.
Yeah.
I know you.
That's in the plan. 5 acres, 100 foot of road frontage. That I'm confident on.
Yeah. So how many road frontage they have?
Approximately at least 1,100 that I know is still available.
10 houses, but
Well, that's 11 houses, 100 foot.
again, I don't know without looking at your encroachment permitting and all that what would be allowed or I assume that's using their 1,100 foot, is that 18 acres, that has 1,100 foot?
No, that's utilizing the full, I believe it's 140 acres.
Yeah, and that's the purpose
Property.
of your zoning being ag. You preserve your 5 acre or more versus taking 18 acres and putting 6 houses on 18 acres. I mean, let's say I own the property next door to it, and I decide I want to do the same thing. How do you tell me no?
No.
Once you ring the bell, you can't unring it.
Mr. Volker, I'd like to address a question to you regarding the linguistics of the comprehensive plan. It appears to me that one of the things that you keep referring to that is in the KRS 100-211 is the major changes you keep talking about. What are you referring to, the major changes on Baton Rouge Road or the major changes within the county on the comprehensive plan? Because as I see it, there's been no real changes on Baton Rouge Road, so why would the comprehensive plan have to be changed at this time if there's no changes on Baton Rouge Road?
I agree 100% with what you just said, and that establishes why you can't grant the zone change.
Well, see, but I actually beg to differ. I think there's been a lot of growth and development, a lot of properties for sale, a lot of new developments. Yeah, there's been new developments. There's been folks that have bought properties, and
Again,
but I mean, I just beg to differ. I think there has been growth.
Somebody posted something, I guess, crazy.
I'm not saying the road itself, the wideness, the width has changed, but I feel the development has changed, drastically increased year after year within this county.
That's your problem.
I guess what I'm addressing is you're saying the comprehensive plan needed to be changed if there was major changes.
2 ways to do
They're
it.
saying
So
that.
generally, you have a land use element. So for example,
But you said-
I've represented somebody before that the comprehensive plan said, yeah, this is farmland, but we believe this intersection on the AA is appropriate for future commercial use. So while it was still zone ag, I said, page such and such of the comprehensive plan says this needs to be commercial use. That means prong 1. Basically, when you say it's consistent with the comprehensive plan. Then you go down because here the comprehensive plan says Baton Rouge Road needs to be widened, basically before you develop anything. So again, it's not germane to speak of the county because you spell out Baton Rouge Road in your comp plan. So the issue is, let's say this thing was still sitting there, Ag 1, and you all went through and realigned and made it a 2-lane road with a turning lane on Baton Rouge Road. Well, you pretty much put the world on notice at that point. Baton Rouge Road is open for development because in your comprehensive plan, you specifically say that. We want to develop this, we need to look to widen it, realign it. Again, that's all the stuff that goes into a comprehensive plan when you adopt it. So,
I guess, see, that's not making sense to me because I don't see us saying we're going to develop Baton Rouge Road.
that's why I'm saying that that's why you don't change zoning because look at your record. I don't think that there's anything in the record that shows a major change to that area.
Right.
So
That's what I'm saying.
Yeah, so if you don't have a major change, then you don't meet the statute because you don't have a.
Yeah, but our comprehensive plan at this date and time does allow us to go from RA to RR. So how can you say that it doesn't accommodate for that situation?
That's what I was up here saying. It doesn't say that.
With
It can
anything,
only
Uh,
go-
views for it and for it against it. You could take a comprehensive plan and find elements in a comprehensive plan that's for an argument or against an argument.
Well, Jack Gatlin's argument, and I watched the video, was preserving agricultural land. Well, by flag lotting it, that is not preserving agricultural land. That's eating up 30 acres versus the 18 acres. So that sort of contradicts what he was arguing.
Just as a matter of, I just want to make sure that they're fully informed on this. So are you suggesting that the part of the comprehensive plan that you handed to me tonight that's titled County Road Improvements, are you suggesting that that they have to go by, that the substantial change is predicated on that?
I'm saying you got one or two options. If I'm going to change it, for example, I've seen people argue the goals and objectives say to increase jobs, and somebody said, give me a zone change because I'm hiring 2 people. We might think it's
complete load of bull, but at least it's something to hang your hat on. So you can hang it on the comprehensive plan, but my review of the record, there's nothing to support the comprehensive plan, especially in light of that. Then it kicks to, you got to show a major change, not to your county, but to this area. So when I look at it, it's like, I'm looking at your record, and I got testimony that confirms the concerns in the comprehensive plan about the road not being sufficient. So where's the major change? That's my only.
I guess that's my question. I mean, the very document you handed to me says the Planning Commission should use this in evaluating development, but it doesn't say shall use this. And you made that point of shall earlier.
Right. 'Cause
So
that's your comprehensive plan, but they didn't use that. You got to look at what they made the motion on. They didn't say it's consistent with the
but
comprehensive
the Planning
plan.
Commission should use this, does not mean they shall use it. Should. They may very well have used it in ensuring that adequate capacity exists on the road system. It doesn't say that these things have to be, they're not a condition. Are you suggesting that the condition precedent to actually making the zone change?
It's one of two ways. I mean, it says the map, to apply the comprehensive plan to justify a zone change, you have to have findings that say, is in agreement with the adopted comprehensive plan. You don't see that in your minutes. They didn't make that.
I'm sorry, maybe I'm
Oh.
misstating this. I'm talking about this document. And
Well,
you
that's
made the
the
point of
comprehensive plan.
expanding, and I know, and I recognize that, but you made a statement of saying that it had to have a expansion of Baton Rouge Road, widened and realigned. Are you saying that that is a condition, is your argument that that's a condition precedent to any substantial change?
Yes, I would argue that if you widened it and you were still zoned A1, the mere act of widening in and of itself would certainly show the zoning was inappropriate to be calling it A1, because you did what your comprehensive plan said, which was clean this road up, widen it, because it says in it, if you want to develop this area, we got to build the infrastructure to make it happen.
But if there were other roads in the county that have been developed and then widened later, that would fly in the face of your argument, would it not?
I think that thing could have been approved without people challenging it in court. I think in court, again, I don't know anything about James Brown's zone change, but I don't know what, I guess I can look at the hint. Again, my job's not to represent Mr. Brown or the people opposing Mr. Brown. Just because something's been done a certain way doesn't make it right. Your father was a judge.
From one lawyer to another, that's a great lawyer answer. Let me just say it.
Judicial electioneering laws. I threw those out in Kentucky for years. They said you can't put up a political sign if you're within 300 foot of a pole. You got private property. I sued, went to the Sixth Circuit, said they threw the whole law out in Kentucky. And the argument of the state was, we've been doing that for a long, long time. Federal court said, we don't care. It still violates Fourth Amendment. So just because maybe you got to pass on stuff doesn't make it right. And that's my point is, again, had P&Z and the applicant developed a proper record, maybe argued certain things, that might be fine. I'm just saying, as you all sit here today, what you have before you, going back to that old commercial, where's the beef? There's just nothing there. Now, whether or not in the future, whether or not they could build it this way, that, or the other, that's not germane to a map amendment request. Because it specifically said major changes of an economic, physical, or social nature within the area. And then if you read the case, that I don't have it in front of me now because I gave it to Mr. Bates, it says you got to make those findings in the record. I just don't. I don't know Mr. Spar, but there's nothing in here. There's nothing in the record. Mr. Taylor's, obviously, you got his application, you got what he says. Then you got, looks to be probably a majority of the people here today that showed up to complain about it and to contest it. And then he says there's been major changes to the area, not anticipated by the plan. So he references the comprehensive plan. Actually, your comprehensive plan did anticipate it. It said, we need to fix Baton Rouge Road before we'd open it up for development. So I'm just saying that, again, while I have no idea what they're proposing to build. It may be the greatest thing ever. It might be 6 individual versions of the White House. But you still got a rule book you got to follow. And if you don't follow it, it doesn't make it right. That's my only thing.
Well, I think the significant changes, and that's what I was looking at, was the issue of the 6 driveways versus one nice wide entranceway to the property. And as far as roadways, I'll agree with everybody. Baton Rouge Road needs to be widened. And Baton Rouge Road's like most of our county roads, not in Grant County, but throughout the state. For example, I grew up on Dry Ridge Mountain Zion Road of 24 houses or less. There's exactly about 350 on Dry Ridge Mountain Zion Road. Dry Ridge Mountain Zion Road it's a little over 2 foot wider than Baton Rouge. But when I lived out there with 24 houses, and as it was growing, that road was still a narrow road, and it continued to get widened as growth went. And I think the biggest thing that weighs on me, and I've been out to the property, I've drove Baton Rouge Road, I know that road, I've traveled it for many years, is that the fact that, we can't stop growth. We got to look at managing our growth in this county. You're not going to stop it. So really, any farm out there could go out with 100 foot on their road frontage, do a flag lot, and there could be, currently there's 118 houses on Baton Rouge Road. That could double in 1 year with development on everybody else's property. For us to govern a property owner and tell them what they can and can't do, we have the opportunity to manage a property owner and try to direct it in where we're not putting in manufactured homes, we're not putting in mobile home parks, we're putting in nice homes that will increase the property values for the neighborhoods, the county. And I mean, that's the options that we've been dealt with. It's not easy to deal with when you look at the options, but that's what you've got to look at. What is the best practice, not only for Baton Rouge Road, and I know as neighbors, they don't want to see these houses next door to their property. But as overall planning and zoning was put together by 12 members that was appointed by 5 entities in the county that was representing the county as a whole. So when they come before us with recommendations on neutral ground, we've got to take those recommendations to heart and look at them. And like I said, I know myself has been out there numerous times looking at the property because it's weighed on me. What is the best for the county, what's best for Baton Rouge Road. And I believe, and I can't speak for the magistrates, I believe they've traveled the roads and looked at it. And, the bottom line is there 6 driveways we want? If we're looking at safety of Baton Rouge Road, I can tell you my past experience in law enforcement, 6 driveways versus 1 driveway, one's going to override 6. As far as the philosophy, the bigger the road, the faster they drive. That's fact. As far as the Airbnbs, we have 200 Airbnbs in the county. I believe that's what Mr. Taylor and his family is putting in. As of 200 Airbnbs, you can ask any of the cities that have them in their cities. We actually govern the ones in our county. We've got pretty strict guidelines that we've not had any problems with our Airbnbs. People think that that's a business they're running. Anybody that's renting a house monthly is running a business. And I will tell you, it takes 30 days plus to get a monthly renter out. On daily rentals, you can get them out the same day. So, just trying to compare apples to apples to some of the arguments I've read, some of the letters that's been put out, and just trying to deal with the fact, because I'm a person of fact, not of fiction on, what ifs and what could happen. I know one of the issues with the lots is the sewage. Well, the property's got to perk. I mean, the health department's got to perk that property, and if it doesn't perk, they can't build a house there. They can't even go past go on that issue. So,
and I'm not discriminating. My whole thing is, again, I just fundamentally take it down to the basics of the zone change. And a lot of that stuff you're talking about, it's not in here. That's again, from the planning and zoning standpoint, if y'all ever been to Lexington, if you remember, like when I was at UK, you had New Circle Road and then Man of War. The way you control your zoning so you don't get your roads beat up on, you designate in your comprehensive plan, this is an area we want to allow a little thicker development. So you kind of tell people where to go. So you try to preserve, because I know Grant County is just like, I represent the city of Falmouth. They have precious little resources for roads and all that. You do it through zoning in your comprehensive plan. You designate areas that you want to say, you know what, this area is ready to transition from agriculture to more residential, more intense. So I don't in any way disagree with the judge is saying. Again, I'm just focusing directly on the record at hand. And again, it's difficult when you're a P&Z body and you don't have a record developed by an applicant. Again, I look back to the application, flat out said no impact. So, your application gave 3 boxes to pick. Any of the 3 would have been the one to mark to say, I'm going to argue this and why I get it. As an attorney, obviously I'd have gone in and I'd try to argue something. I'd have looked at the comprehensive plan. I'd have looked at goals and objectives, maybe done all kinds of stuff.
right or wrong, that's in the past. You've already got a record before you. My position is just looking at the hearing presented to you all, the record at hand, not whether Airbnbs are good for the county or not. That's not the statutory analysis.
Can this meeting be an amendment to the record at hand to acknowledge the changes such that's documented?
No. Yeah.
Right. I mean, because the reality, all of this was chatted. It just was not typed up in that manner. I mean, was it? I mean, as I look at the minutes and look at the if we're talking facts and as to, I take it that you are questioning the application. Well, the application can be redone if that's the issue at hand.
I think it's more of an interpretation probably of if things,
His argument is that there was not appropriate findings made to support the substantial change to the area in order to allow for a zone change. And that had to have been done, if you follow his argument, is that should have been clearly stated within their findings of fact as to what substantial changes they found in the area. I'm not trying to, I'm just trying to, that's your argument, is it not?
That's exactly
That's your
right.
argument.
Yeah, that's
Okay.
exactly right. Stephen was more artful in presenting it.
I've been sitting here listening for the last 20 minutes.
So such that wasn't documented in a way. But
They did
it's
not-
common knowledge. I mean, the
Well,
facts to
okay,
me are,
so-
in this case, are common knowledge. Now, whether or not they were documented in a way,
You don't
Yeah.
want to say common knowledge because.
well, to me, for me it is.
Yeah, but then you get outside of
Yeah,
that.
okay, so
due
when we
process.
started this process, we did say that we were not going to take additional evidence. We were going to only take argument. If we're going to take additional evidence and have a trial-type hearing,
Right, and I don't think any of this is additional evidence.
well, if you're taking what's quote-unquote common knowledge for the area and saying, I'm going to apply that, that's outside the scope of the findings of fact that have been presented to you from the Planning Commission.
yeah, we're taking exactly what planning and zoning's presented to us.
If you want to take additional evidence, then you're having a public hearing,
And
at
they've
which
already
point I
had-
will suggest to the court that will need to be, this whole matter will need to be tabled, and we will need to schedule for a public hearing for allow all the evidence to come back in and do it. I mean, I don't think that Mr. Volker disagrees that we can conduct that hearing. It's just going to require findings by this body, and then we're going to, it's as if that.
This body or planning and zoning?
This
Okay.
body, if we're going to do another public hearing.
No, I would agree. You can have your own public hearing.
Yeah, we can have our own public.
You could say, we don't think there's enough here, we have our own. You have 90 days to act from, I don't know when the meeting, whenever they took action.
Right.
If you don't act within 90 days, then a matter of law, the change goes through, which then, at that point, it would mean if my clients choose to appeal, they would have to appeal to the Planning and Zoning Commission.
I'm looking at the date of the application or the date of the.
Yeah, I don't know when the hearing.
This was sent to you on August the 30th from the Planning Commission.
Yeah,
So-
but it's the night of the vote is the.
Well, it passed on the 15th of July.
July 15th, yes.
So you got August 15, is it 60 or 90 days now?
I thought I read 90 earlier.
90.
It used to be
I've read
90
it,
and they,
yeah. I thought it was 92.
let's see.
I'm just, so if we're not hearing additional evidence, then what are we talking?
Yeah, that's what, I mean, just,
Advocate. I'm not advocating.
I don't think we'll be.
Understand you can take a vote on the findings of the commission and their recommendations and the arguments made by Mr. Volker, but no additional consideration to any outside facts other than the findings of fact and the recommendations made by the Planning Commission. If you wish to hear additional evidence, make your own findings. That will require another public hearing to be conducted.
Do you feel there's the need for another public hearing? I mean, I've watched the public hearing, the recording.
I mean, the fact remains that there's been other property sold out there already that has addressed this issue. And evidently the planning and zoning has let it go through before.
From Triple Ridge in towards the Williamstown, everything has been sold out there. It's been sold on 5 acres or more.
Yes.
And what's it- and what's
that
it-
I think is a fair statement,
Yeah, that is fair, that they could be bought with the 100-foot road frontage.
with 5 acres.
And that's what we're,
And they still remain agriculture.
no, they switched over to residential.
Yeah,
That's what I'm saying.
Zone.
Well, at one point they had.
Yeah, the question is what I said before, it's,
There has been development.
if it's not passed, then he can go ahead and put the properties in with flag lotting it, with a 100-foot road frontage with 6 driveways.
Correct.
There's no precedent set to tell other people they can move in. Because once he's approved, other people can develop the same way. There's been no major change, and the road just continues to get worse. So, for the sake of consistency,
Well, that's not totally true as far as the road improvements. As more people build in, then the road would have to be widened. Yeah.
Yes. Well,
Yeah.
some of them.
I'm sorry. Mr. Volker, are all these people making comment now represented by you, or are these additional people that are not represented by you?
Some probably are, some probably not.
Okay. I'm just trying to figure out what, yeah.
Okay.
And, yes. And the knowledge behind that is, because I'd asked that on other constituent matters, from a grandfathered in standpoint, we have multiple properties in Grant County that are less than 5 acres but still have a residence on them. And as things evolved over time, those respective properties are grandfathered in, so you can pull in manufactured homes or build stick-built homes on those properties because one previously existed, if it did, which is why we've got a variety of less than 5 acre lots throughout Grant County.
But a minimum of 1 acre, so.
And I would ask if it had a existing structure, and if not, then maybe they also came through and asked for a similar type of change, because we see these come across our desk more often. I mean, probably a few a month at times, and sometimes 7 and 10 throughout Grant County, just because the growth has existed as far as needing residential homes.
Generally, I would assume your mapping that requires a minimum of 5 acres for the first point. I believe what you guys refer to as non-conforming use, which is my non-conforming use goes away, it cannot be enlarged at that point. So, to the extent somebody's allowing non-conforming to be expanded, that's contrary to the BOA cannot grant
I don't,
a variance contrary to zoning law. They can grant like variances, setbacks, things like that, but you can't, if you were required to have certain things you just can't do, like you got a sign, that says 30 square foot sign, BOA can't just say, well,
No, but I think what she's referring to, if you've got a 30-acre farm with a house on it, you can deed off 1 acre with that house and separate the 29 acres from the farm.
that's, yeah, probably, that's,
And that's what's commonly done when people want their kids to build on the property, is they'll separate the one residence into a 1 acre lot, and then they've got 29 acres to work
Well-
with.
I think these folks are saying they're fine with that.
And they were referencing like historical, like how is it that we have so many like half acre and 1 acre and 2 acre lots? And I was educated by the planning and zoning director that it had more to do with grandfathering in, that there was an established residence there.
You all didn't have zoning until what, mid-90s maybe?
No, it was earlier than that.
Was it?
Yeah.
80s?
Like sometime I thought in the 80s.
Built prior to
Mid.
the zoning, it's got to go all.
Yeah.
And many of those properties still exist.
Well, I think at the end of the day, it boils down to safety, and my concern is the driveways. Trying to eliminate as many driveways, but no, that's all right. Well, it doesn't totally open the door up. Yes.
I have a few questions that maybe you can answer for me, or maybe the attorney here can answer. Because most things he said, there's probably only 2 people in here that really understands what he's saying by law, under statutes. But if any other person here that owns a farm out there decided that they wanted to, what they're going to develop, I don't know what the definition of develop is there, because I know there's multiple homes built on that road in the last year. Yes, they're probably on 5 acre lots, but they could have put in for a zone change, correct?
Yes.
If they had the road frontage for that, they could have put in a zone change and done exactly what he is wanting to do, as long as it was passed.
Yes, they would have to go through the process.
So that would be their decision to do. Just like when he bought the property, it would be his decision to do, as long as it was passed by planning and zoning or the committee that's in front of him today, correct?
That's correct.
I just want to be clear. I was not clear with what.
Okay.
And I agree wholeheartedly. I think that's the issue, is once you give it, you can't take it away. Because all of a sudden, they get the build on this, and I decide I'm going to go try and capitalize on the north. I'm going to drop a bunch of Amish cabins. I know how to do it. I own property down Laurel Lake. I know how to work my way around zoning like a magician. So these folks get upset. They go sell me 10 acres. I come and I do it. I pop many villages galore. You can sit there and say, well, we said only 6 lots. I'm going to say, why am I being treated differently? What's the basis? Why do they get different treatment than I do? That's the point of what folks are saying.
And
They could also do the same thing if they wish to, if they have a property to do it.
well, and the application has restrictions in it.
Yeah.
It's not a blanketed free-for-all.
Okay. Yeah, thank you. Well, that's not totally true, because you can actually just run it 100 foot wide, do your flag lotting
And do the acreage in the back.
in the acreage in the back of the
This is
property.
the best way to do it for to preserve the road.
Please let Mr. Taylor speak now.
Well, I mean, this is, honestly, it would be less expensive for us to do the flag lots down the road. We want to do it where it looks better, so that when you turn down the road, 1, it's safer. 2, we have all of them in one area, so that we're not, their agricultural land that they keep referring to, that when I shoot doves on, that's obviously not agricultural, and they get pissed off about that. Well, we're trying to make it we'll have one road. They're on 2.5 acre lots, so we're not putting them on 1 acre lots. Some of them are even over 3 acres, so we're not talking like we're jamming all in like Mr. Walker said. We're not building Amish cabins. It's written in our agreement with planning and zoning that we're putting a stick-built house, 1,400 square foot with a septic system on the smallest lot is 2.3 acres, I believe. I mean, and it's already there. The house is there. It's appraised for $410,000. We're not building Omnis-built cabins and stuffing people in. And we're definitely not having parties and all the other nonsense that they've brought up that's happening out there. The point of it is it's safer. It's going to look way better for everyone on Baton Rouge. I plan on building a house on the next ridge down. I don't know that that'll happen or not, but I don't know that I want to live over there, to be real honest with you. But we're gonna have this would be way nicer looking for the county, for the community, for everyone on Baton Rouge. Because I mean, I can put them down the street and put flag lots. I'm not a big fan of flag lots. I think they just don't look. They don't look good. I mean, I only other thing I'm doing with the property is hunting on it. I can build a house. There's best hunting in the counties and the subdivisions right up here. So, I mean, you could put houses right down the road, and I can hunt right behind them and do just fine. I'm trying to do this because it's the best way that it'll look the nicest, and we're not doing anything, we came here, planning and zoning passed it. We're here tonight to see if we can go forward with our plan, which is build a road, but housed on 3-acre lots, basically, is what they average. 2 acres less than what, than what already I can do by doing flag lots. I mean, that's the simple fact of it. Like, I'm trying to make this look, it's costing me more to make it look better. They might not appreciate it, but somebody will eventually.
Does anybody have any questions from the court for Mr. Taylor? No? Okay, thank you, Mr. Taylor. Yes, sir.
Jim Violet, I live 4560 Baton Rouge Road, less than a mile down from where his proposed change is. So obviously the idea of the council here is what is best for Grant County. Is that correct?
And Baton Rouge Road, yes.
Okay. In your eyes, so outside of the obvious for this gentleman, which is nothing more than income and return on his investment, how do you feel, or how does he feel, these changes to Baton Rouge Road will improve the lifestyle of the people that live on Baton Rouge Road for over 100 years? My father-in-law, you're talking about the small lots? My father-in-law lives on property with us. My wife lives there. My son lives there. My mother-in-law lives there also. On property he bought in '69 and has preserved this as a lifestyle of Baton Rouge Road. And then this gentleman wants to come in and completely change that, because there's a statement they use on the internet. It's called NIMBY, and it stands for not in my backyard. So he's talking about the hunting and the fishing that's going on, but it's not happening in his backyard. It's not happening in your backyard. So, for instance, he builds these homes. He builds these homes there and brings these people in from wherever they're coming from, and we have no idea how they are. If any of you have been hunting, tell me if I'm lying, but hunters climb fences. They go out and get on other people's property, because I've had them on our property. We do not permit hunting on our property, but I've had to chase people off the property before. You're going to have all these strangers come in from who knows where that have no idea. Most of them are probably from the city. I don't know that for a fact. And you're going to think that they understand how to live there or how to treat the lifestyle in that area? I don't think that's possible, right? They're going to be bringing ATVs in or who knows what. They'll be out wandering. Excuse me, if my turn to speak. So I'm going to give you a perfect example of how this works out. So, for instance, I'm assuming most of you live in a relatively nice area. Okay.
I've got 6 Airbnbs as neighbors, so.
Okay, well, congratulations.
Yeah.
I'm sorry, you decide which one applies.
No problems.
So, for instance, let's say they brought over, let's say the United States government brought over a family of Afghanistans that they just rescued out of Afghanistan, okay? Let's say the house in the backyard, in your backyard, was up for sale, and the government came in and rented that house for $5,000 a month and put those people in there. How would you feel, regardless of whether or not they're good people or not, how would you feel about those people living in your backyard? you'd probably have some concerns. I'm not going to make that judgment for you. You can make that judgment for yourself. But I'm thinking you'd have some concerns. So these Airbnbs that he's proposing to put in on our property, which is right next to this gentleman, right across the street from these folks, right down the road from them and them and them. I know all these people for 30 years already, right? It's like you're taking these people and putting them in our backyard because it doesn't impact you. So you're talking about what's best for Baton Rouge Road. I don't think you're asking Baton Rouge Road what's best for them. You're thinking that you're making a good decision for them. But you can tell by how many people are here, and I'll guarantee the first time this went on, there were twice as many people here. I couldn't make it to whatever hearing it was that was going on because I work, and I had to be traveling that day, so I couldn't make it, or I would have been here that day also. So, you know, if you talk about taking a vote, don't vote with them. Vote with the people in here, right? You want to do it democratically. How many people here want that?
But also we receive calls of support from people.
Well, that's understandable.
Yeah.
What?
You have a right to wake up on Saturday morning at 7 o'clock in the morning, and by 7:45, you hear people letting off shotguns. It sounds like it's coming right out of your front yard.
Let me show you this, sir. See this right here? This is from me hunting this weekend, dove hunting too. 7 a.m., 7 p.m. on my land, on a private citizen's land that they own.
That's fine and dandy, but this is driving down the very value of the land that my father has got there. It's driving it down. Because who's going to want to come in and buy that land knowing that there's going to be people thrown in for year-round to go through this? Because it's the only way you can make an Airbnb pay, and that's to keep it full.
And to keep it nice.
Well, but I also think people are losing line of sight as to why we even have an Airbnb discussion in this community. We have an Airbnb discussion in this community. It's a discussion point because of the ARC. It's been here for 5 years now. It's been very successful. We do not have enough hotels to accommodate the guests, which is why we have close to 200 and counting. Folks are...
Put them on a main road, though.
And they are. They're up and down this main road.
Well, fine.
And I think as a private developer, you should have a choice to decide if you want to rent your home, if you want to build additional buildings,
But he
whatever
doesn't
that may
have
look
he
like.
doesn't
And
have
this,
a regular home there.
well, in this plan, this plan, well, and you have a choice within your own property.
We're great if you take care of Grant County, we love you for that. But you're not caring about us.
There's,
You're about-
well, and that's, well, but I'm saying that we have a track record in this community
So
of
I'm going to give you the
positive.
track record over the last year,
pos-
okay? On my property, which is at the top of that hill, I have what I think is a beautiful two-story brick home there. And the road goes down the
Yep.
creek from there,
Yep.
okay? Within the last 2 years, or within the time that these homes have been built there, I can sit in my front office, because I'm working at home sometimes, and watch the concrete trucks come flying up the road, going over the little bridge that's at the bottom of the creek there, which I don't know that it's rated to carry concrete trucks over. They have destroyed the corner right around my house there by driving up on it, knocking rocks up. There's tires down there from the trailers that come up. I have seen, I don't know who they are, but they end up at his property. I have seen those gentlemen coming in late for work, flying up that road, pulling trailers, running people off the road. I can sit there and watch them from my house doing this ever since they've begun that construction there. And like I said, it's not in your backyard. It's in my front
Well,
yard.
and I would-
I can
Can
watch this.
I interject at this point? I just want to caution everyone as we go on
That we need to
forward
quit
down this
talking.
line. Well, I just want to make sure we stay on the track of, we started this off by saying this was an argumentative only hearing based upon the findings
so.
that were
Thank you.
made at the Planning and Zoning Commission hearing.
Got to ring us
Okay?
back in.
And now, we're going to go, once again, I think the issues before this court right now are you accepting the findings and recommendations of the Planning and Zoning Commission as stated, Or are you going to conduct your own public hearing at a later date and hear argument from whomever wishes to speak at that hearing? Or you can make your own findings. This was the third one I left out a couple minutes ago. Or you can make your own findings as to why that does not meet with what you believe to be in the comprehensive plan and deny it, but you have to make your own findings as to why you do not believe that recommendation meets with the comprehensive plan, which, that's going to require you all to make some statements as to why that's not the case. Once again, those are your options. I believe they're in front of you. If Mr. Volker has a difference of opinion as to the law, that's my reading of the law, and I also believe it's 90 days. Mr. Volker may disagree with me about that matter. I think it's 90 days, so I do think you have time to schedule that public hearing if you wish to do so, but I just caution as we go on, and I understand this as a passionate subject, but at the same token, you all have decided at this point that you want to hear just what the Planning and Zoning Commission heard and arguments thereon, and if we get outside of that scope, we're getting into the public hearing specter of this, at which point we would need to really schedule this for a public hearing.
Correct. Thanks, Stephen. Yep.
I'm down in road frontage. I think one thing, you say it's 100 foot to get a curb cut. So if they've got 1,000 feet, but 150 acres, you get 10 homes. And the one good thing to preserve again, this goes to the major change argument is, so let's say you had 10 homes, but obviously, because if you look at the map, they own the property here. I've never seen, in all my years, I've never seen an applicant not include all their property. Generally, if you want a zone change, you want it all. So, I don't know why the 150 acres aren't being sought for this.
Because I think he's trying to contain it and to keep the agricultural aspect in the larger pie.
But the flip side is, if you've got these, so instead of having, his original plan had 10 lots, so now he said, well, I'm agreeable to go down to 6. But if you, in the event you were to take the whole 150 acres, and let's say you can do 10 lots, you got 10, but each lot is probably 15 acres. You're looking at, you can arguably preserve. I think what the folks are concerned about is, when you look at plans that stub a street to the end, and you've got everything on each side that's still subject to getting a change. And I don't know how you tell the future people no. I don't know how you could say it was major and justified today, but it's not. We're going to shoot it down if somebody else does it. I mean, I don't know. Maybe I should go up there and try to buy some property next door and build my own subdivision soon. I think that's what you're going to have to contend with in the future, because once you allow it, it's hard to take it back. I can take it back at that point.
Well, you don't always have to allow the next property. It depends on the circumstances and what's being done with it.
Single-family homes. What if I want to build single-family homes as well? I'm going to buy 10 acres and I want to put 10 homes. I'll stub a street and I'll do that. I mean, I don't know how you tell me that.
But that's not what we're doing here. This is 18, almost a little over 18 and a half acres.
But what happens if their development takes off and all of a sudden they decide, you know what, we got the adjoining property, or we go to the rear? I don't know how once you ring the bell, I don't know how you take it back.
Yeah.
Because
Sorry to cut off Mr. Volker, but quite frankly, these are arguments that were not made, I believe, at the public hearing. And so once again, we're getting a little bit outside the scope again. I'm just suggesting that if we're staying within the scope, stay within the scope. If we're not going to stay within the scope.
See, and that's why we have you here, to ring us back in.
I think I think the request from these folks are keep it A1. If they want to build their 10 lots and utilize the encroachment permit process, they think that's a better outcome than the possible proliferation of subdivisions.
Okay, thank you, Brandon. Based off of Resolution 00-05-21, everyone has had an opportunity, I know, to go through it front to back. Any questions that we can discuss here at the bench? If not, I'll entertain a motion.
I make a motion this evening to entertain Resolution Grant County-00-0521, a resolution of Grant County Planning Commission recommending the approval for a request of United Skills Services for a zoning map amendment Such zoning map amendment being a zone change from A1 to rural residential RR on 18.85 acre site located on the southwest side of Baton Rouge Road, approximately 3.6 miles west of US Highway 25 in Grant County, Kentucky, and providing the recommendations being forwarded to this governing body, Grant County Fiscal Court.
I second.
I have a motion made by Magistrate Riley, a second by Magistrate Codon. All in favor by saying aye.
Aye.
Any opposed?
Aye.
We have 3 in favor, 1 opposed. Motion passes.
Resolution.
Resolution.
We just approved the resolution.
Okay, so you don't do a zoning ordinance? We have not in the past, we've done a resolution adopting the
I'm not on it yet. And then-
You won't do by ordinance? Okay.
So tonight's the night, I'm just asking because.
Yeah.
I've always done it by ordinance.
Okay. No,
Yeah. So, okay. So tonight.
3 years in, this is how we've done it.
Okay, so the resolution is.
Except-
That's your final action.
That's the final action.
Okay. I just want to be clear, yeah. I'm going to check that. I've never sworn not done my ordinance.
Whatever happened to hearing about children playing in the country? You stop having kids. They're become selfish. And then they want to develop things. And they get better. Even though I have 8 kids on that road, 2 miles, a half mile now. I was camping with them every weekend in the tent. And I heard loud music till 5 in the morning. And then cars going down the road. People stop having kids. They want more for themselves and less for them. I want my kids to run around in the country, and I want to be able to feel safe that they're there. I thought I could do that on 90 acres. I thought I could live in a Grant County that would also like children to be country kids and to go play out in the creeks and not worry about strangers, because that's what they are. To come here and just shoot wherever they think they can. Oh, was that the shot that I wasn't supposed to shoot at? I don't know, because I don't know this land.
Okay, thank you, ma'am. Okay, moving on down the agenda. Old business number 7, we have none. 8, new business, none. Reports. Everyone has in front of them the treasurer's report, animal shelter's report, road supervisor's report, building inspector's report. Has everyone had an opportunity to look over it?
Yes.
Yeah, we've looked over it.
Okay, any questions? If not, moving down to jailer's report. We have the jailer, Mike Webster, with us.
Good evening. So tonight at the jail, we have 199 occupants, 25 are county, 174 state. We're still mowing and picking up trash as we can. Happy to entertain any questions you may have.
Are
I think
the cities or any of them, are they allowed to use any of the prisoners as of right now because of all this, or is that
So-
still on hold?
As of right now, and it changes daily, they're still allowed to use them.
Okay.
We are asking that the supervisor be vaccinated. The state has mandated that the only ones coming out to work are
Or
vaccinated.
vaccinated? Okay, good.
And that'll change daily. No road crew goes
no kidding.
the same day to the same place, and some of our rules change daily as well too.
I just saw on the news, or had Newsflash pop up, I think it was yesterday, that there's now another new variant
Yes.
that's been found in California, so.
And as of right now, as far as pickup for state inmates, there's 37 jails on the list that we're not allowed to transport from at the moment because they're experiencing COVID issues. You guys have a good evening.
Thank you, Mike.
Thanks, Mike. Moving down to sheriff's report. We have Sheriff Brian Maines with us.
So, for the month of August, we took 1,006 calls in Grant County. I don't have the full report ready yet. The holiday kind of slipped up on me. I normally do that on Mondays.
We'll cut you some slack.
Yeah.
However,
The only other thing I have to report, we just got our AUP audit back today, which, if you're all familiar with, is the quick audit that you can apply for. So since the sheriff's office had a good audit in 2019, I was able to apply for the AUP audit, which is quicker and cheaper. I'm not sure financially, do you know how much?
It's quite a bit cheaper.
Quite a bit cheaper. Received that back today, myself, the judge, and the treasurer. No items found. It was great, so we're going to continue to get the AUP audits. That's all I have.
keep it up.
Well, thanks a lot. Good job.
How's our deputies? I mean, we still running good on deputies, or is there any?
We're trying to hire one right now.
Okay.
Lateral, we have one position open, and then we obviously still have Bo Hammonds in the academy, waiting
Good.
on him. But
Everything going okay there in the
Yeah.
academy?
He's home this week for the holiday. They always shut down for a week so that the trainers there can get their in-service. But going good.
All the equipment holding up?
Everything's holding up. We have, well, let me back up. We did have one vehicle that somehow got salted in the fuel tank and the oil. And that was
What?
the K9 vehicle. Yes. We can't figure out where it happened at. We believe it may have happened in our parking lot because they would have had to have had access to the hood, and he always cracks his hood in our parking lot. We wasn't able to find anything video footage-wise due to where it was parked, so we're addressing that issue. But we do have it at the shop and are currently waiting on an engine.
Salt and sand,
Just salt.
Salt.
so clearly was intentional.
Yes.
Yes. Fuel
Un-
tank and the oil. Correct.
Whose cruiser was it?
Lee Jacobs, K9. But other than that, vehicles are going
Is he
good.
still assigned to schools?
No.
No. Okay.
He's on the road.
Wow, that's ridiculous.
Okay. Well, thanks a lot.
Problem.
Moving down to judge report, just a few things to add. If you noticed out front, we had some crack spots in the sidewalk, and the stairs were actually had sunk down into the stairwell quite a bit. So I've got Morris J. Webster working on it. If you hadn't been over to the sheriff's office, he had fixed the concrete issues we had over there that was raised, made the handicap accessible parking or area where it's now by code. Before the two pieces were there may have been code in '99. They're not code now, but they had raised where you could trip on it. So, as always, trying to go through, locate anything that would be a liability of sidewalks that are raised or different things or cracked, getting fixed. Also, the building behind the sheriff's office, and I've talked with Roger, I may have talked with the rest of you on it, is that it was built below grade level. It was causing the bottom of the building to rust, water starting to come in. So I've hired Greg Traylor, who is out there digging around the building and putting in the retaining wall pavers, and we're actually cut across the parking lot and put the gutters of the building going out the back instead of all that water washing back into the building.
I'm surprised it's lasted as long as it has.
Yeah, and it's, I know that the jailer has built a records room in it, trying to have an area to store records, so, we need to deal with the issue about water coming into the building. Not only that, it's rusting at the bottom because it was about a foot or two that was below grade level. The metal was. So they're going to put that retaining wall in, like I said, made out of 18-inch pavers, and not only will it look good, it will serve our purpose to keep water out of the building. Besides that, that's all I have. Magistrate Humphrey, you have anything?
No, sir.
Magistrate Kodar?
No, sir.
Magistrate Riley?
I
Okay.
think we did enough.
Yeah.
Thank you, sir.
With that, moving down to item 10, we have citizens' address.
Mr. Rose.
Mr. Rose?
I'd like to, I don't have a dog in the fight on 6C up here, but I think the court should really take this as a learning opportunity, a serious learning opportunity. As a taxpayer and a resident in Grant County, the county wants growth.
Well, in order to have growth, you have to have infrastructure. And I live off Verona Mount Zion Road, which is a no-fault road. There's no line down the center. And the state did a big favor to us by putting edge lines on it, so when it's foggy out or whatever, even that we lived there, when it's foggy out, you can't tell where the road is because the road is like curves all over the place. So I look at going out to Baton Rouge Road. That road is narrower than Verona Mount Zion Road. Do you know how many places or the land ownership out there, how many are zoned agricultural and how many residential places there are out there? Because you look at that road and the thing the court should do is push back on planning and zoning. You can't put more residents out there unless you widen the road, because when you integrate, you know what mission creep is? What I call mission creep is where you go from in this case, where you go from agricultural zoning to residential. Pretty soon the residential starts creeping in. And when you have that, then you have more demand for water, for road, for safety, and safety is the number one concern. Try to get an ambulance down that road. When you start putting more you should push back on planning and zoning, in my opinion, and widen that road before you do anything else, before you put any more homes back there. And I don't care how far back you do, you need to do that, because you can't have this county grow with more people without doing the infrastructure. You have to do that first, because what happens to safety? And that should be your number one concern, is safety, period.
And it totally wasn't, in my point of view, due to the fact of 6 driveways versus 1. That was the main safety driver to me, because the property actually allows for even more development.
I don't care. I get lost in all the weeds there. But I look where you have residential and agricultural integrated on Verona Mount Zion Road. I mean, there's tractors going up and down that road. You cannot do whatever the speed limit is. You always have to be wary when you live there of what's coming. Every day there's something different. And living out in the country, it could be even animals. You don't know. And then you get all these people coming in from out of whereverville, and they think they're in town when they drive, just like a gentleman over here said, But I think you need to really push back, and I think this is a learning good exercise that you need to push back on planning and zoning before you start dividing up more farmland. Take a survey, inventory of how much farmland you got out there and how many people actually farm that land too. I mean, how many pieces of farm implements go up and down the road? Because that is a country road. It is agriculture.
But we can't stop splitting up these farms and people building on them.
Put the road in then.
That's what
Do that first. Push back on those.
But Dave, look at the history of the roadways. I mean, look at Mountain Zion at Florence. I mean, that road, they're now widening it. Roads normally, until people start building, that's when roads get built. No infrastructure in our country is built like we think it should be. I agree with you.
Judge, that Baton Rouge Road should be at least as wide as
But Mountain Zion Road looked like that.
Well, it should be as wide as Verona Mount Zion Road.
That's what I'm saying. Those roads got widened over time. But I've lived here for 56 years. I know how they've got widened.
I realize that. But what I'm saying from a safety issue and just bringing in, the ARC's bringing in all these people, visitors. And I went to a meeting and I heard this lady start talking about, well, when the people come in, they don't like looking at shabby barns and broken down buildings. They want, we want to have a nice presentation from the county's respect. Well, a lot of these farms, only people left on them are grandparents. The kids don't want to farm anymore.
And that's why they're selling the properties.
And then
if you can afford it, they're
with
buying
this
it.
scamdemic, this COVID stupid stuff, people are able to work from home now. So we have people that used to live in Cincinnati or wherever, and they hated it, but, I call it legalized prostitution, selling yourself for money. You'd rather do something else, but hey, it pays the bills. So what do? Now they can work from home, so they're dividing up farms, and people are moving out and working out of their home.
No.
So
Well, that's
all I'm
going on.
saying is I really seriously hope that you all really use this as a good training exercise.
Well, we don't disagree that there's roads in the county we need to be widening, and that's what we're trying to do.
But you can't keep putting people out there and then, God forbid, somebody gets killed or has an accident out there, or the lady said she's got kids running around. Yeah, we should think safety and push back and do an assessment of what it would cost to widen that road for however far down you think you have. You should do it,
Yep.
I think that should be the number one priority.
Safety is my number one priority.
Well, that's the only thing I wanted to tell the court. I don't
Okay.
have a dog in the fight, but I know just living where I live, you encounter all kinds of weird stuff, and you just can't be in a hurry when you leave home or you're coming home.
Well, and you can't even be in a hurry on our secondary state roads. I was telling the judge that 9 times out of 10, I'm slowing down because someone's speeding up, passing me on state roads, et cetera. I mean, it's safety is a concern, but like growth and development is happening in this community. And that has to be here in order to have the tax base to further develop the infrastructure.
But you got to have the safety, and
and
we're putting the cart before the horse. I mean, that's all I'm trying to tell you all. I just hope you do kind of push back a little bit on those folks because, hey, everybody wants everybody coming in. Yeah, we want to be like Florence. No, we don't. We want to be a rural community, period.
Yes.
Anyway, thank you for your
Okay,
time.
thank you, Dave.
Thank you, Dave.
Does anyone else have anything to address the court? If not, before we adjourn, just remind everybody, our next meeting is Tuesday, September 21st, 2021, at 6:30 p.m., and it'll be by Zoom. We'll have the agenda posted on the door. Also, we send out the agenda to anybody that's requesting it. With that being said, I need a motion to adjourn.
I'll make a motion, we adjourn.
I'll second.
Motion made by Magistrate Codar, second by Magistrate Humphrey. All in favor by saying aye.
Aye.
We are now adjourned. Thank you all.